Hello, everybody. My name is Cynthia Gallardo. I hope you're doing well. If you can hear me, please put in the chat that you can hear me. I definitely want to make sure that we're moving in the right direction. So once again, if you can hear me, please put in the chat, I can hear you, or if you can include your name and where you're from, I would greatly just like to know who's on the call. I always like to know who we're working with here. So once again, my name is Cynthia Gallardo, your leading legacy lawyer. And as you can see from the presentation, I also have a legacy, yes, just as you do. You can see a picture of my husband, Danny, and my son, Elijah. So, our son, I should say, Elijah. So we are here as part of our legacy, and I want to share some information with you that will really help you protect and preserve your legacy. And this presentation is specifically for anybody who has a legacy, and especially for busy parents, because you'll find out how you can protect and preserve that part of your legacy. So once again, if you can hear me, if you could please include in the chat that you can hear me. And also, just so you know, the session is being recorded. We will have it available for discussion later, or if you want to, review it later. Okay, so we'll go ahead and get started here. So for the next 45 minutes, I want to share with you what no one has told you about estate planning. I know you've probably heard a lot about wills and trusts, but what exactly will best benefit you? We'll be talking about that today. So today's discussion will be like a personal legal consultation with me. We'll talk about wills versus trusts, which is right for you, and are any of those right for you? And then also a special gift for today's attendees. Yes, I do have a gift for you. First of all, I always say that a smile is free, free of charge. It makes a huge impact, but I do have a gift for you today. And then also question and answer open. Now, keep in mind in the chat, if you have any questions throughout the process, please let me know. And I'm going to go ahead and see if I can type in there and you can see that. Okay, so let's move on to the next piece. So you are in the right place if you know you need an estate plan but aren't sure where to start. You are curious how long the process will take and what's involved. And also, you're wondering why you can't just do your own estate plan online. I'm sure you've probably seen a lot of template or cookie cutter estate plans, right, online. I do want to share with you that in Louisiana, I definitely would caution you about that, because Louisiana is very specific on what's required in a will and also a trust. So it's best to be able to, instead of cookie cutter, making it specific to your needs. So just as a precaution out there. Now, here's a little bit of information about me. You can write it down, but also, as I mentioned, you'll be able to get a copy of this presentation or the recording. So my name is Cynthia Gallardo, your leading legacy lawyer, and you have my information there, my contact phone number, and my email as well. And here's just a few of the memberships that I'm a part of: the Louisiana State Bar Association, Wealth Council member, the American Bar Association, the Lafayette Bar Association. I'm a graduate of the National Entrepreneurs Association and also the American Immigration Lawyers Association. Now, some common objections when you think about a will or a trust is my spouse will take over, so why do I need this? I'm too young. I don't need a will or a trust, or I don't even have enough money to include in a will or trust. So I just want you to keep those in mind, because all of those you can actually X out. Nobody is ever too young to proactively plan. Tragedies happen, mistakes happen, things happen, life happens. And actually, you'll find out in the presentation, there's very minimal amount that you need in order for a will or a trust to be applicable. And also, not necessarily, because if a person dies or passes away without a will, it's called intestate, and the intestate law would take over. And I'll talk a little bit more about that as we go through the presentation as well. So I do want to ask you this personal question here. What's the risk to your family if you don't have a plan? Very important question, because if you don't have a plan, keep in mind the risk that will be involved with that. So then we get to the next piece here, the goals of estate planning. So you want to be able to give what you have to whom you want, the way you want, and why you want to give it to them. You'll be able to lay that out. And care for yourself during your lifetime, such as in capacity, health, and financial. care for yourself, protect others, such as your spouse, your children, should you become incapacitated or lose your life, and avoid probate court. Also, you'll be able to fulfill your charitable intentions, pass on your values and ideals to your children and grandchildren, and then you'll be able to maximize your assets distributed to your loved ones, minimize your taxes due at your death, and protect assets from creditors, divorce, bankruptcy, for future generations to come. So my sisters and I we were actually talking about somebody being a trust baby, right? And a lot of people think that in order to be a trust baby, you have to be able to have a lot of money or be filthy rich. That's not necessarily the case, and I'll go through some of that information with you as well. And when I talk about legacy, I'm talking about your material assets, but also your lessons learned that are part of this process as well. And of course, we always want to maximize your asset distribution and minimize the cost to you. So some of the documents that are involved with estate planning are the last will and testament, or the revocable living trust, and the power of attorney, the advanced healthcare directive, the final disposition instructions, nomination of guardians for the children, optional separate trust for children, and then an irrevocable trust for states that are valued more than $5 to $6 million. So we'll find out what the needs are for you specifically. And then also, interestingly, what I do is I bundle a lot of these for the living will and bundle into the revocable living trust and also last will and testament. So do you have an estate plan? Great question. You might think you do. Excuse me, you might think you don't, but you do. And what I mean by that is if you don't have an estate plan on paper documented, then the state has one for you. You'll be called there will be what's called an intestate plan. That means you don't have a will, or you're not a testator, right? You haven't created a will or a trust. Then it'll fall into the hands of depending if you have separate property or community property, based on the way Louisiana law is written. So I'll just give you an example with that. So for separate property, the property would fall, or the assets would go to the descendants first, then the parents and or siblings, then the surviving spouse. Now I know that's a shocker for many people, and that's if you do not have a will or trust and it's separate property. Now, if it's community property, and Louisiana is a community property state, it'll go to the surviving descendants first, and the surviving spouse will have what's called a usufruct, or the right to use the fruits of that particular asset. So they'll be able to live on that estate of the deceased property, community property, until that person, either the surviving spouse, right, either dies or remarries. So once again, that surviving spouse would have a usufruct on the community property, and they'd be able to live there until they remarry or pass away. So a lot of people don't realize that. So it's important, if you think you have a plan, you want to recheck it. If you think you don't have a plan, you actually do. It's part of that intestate plan, which we'll talk about going into intestate plan probate. So it's just a state that has written one for you if you don't have one yourself documented. And then also the estate planning is opting out of the state's default plan for your family and assets. So you have a choice. You can make that decision today if you want to opt out of the state's plan and create one for yourself and your family to protect and preserve your legacy. So doing nothing means you get the default plan, as I mentioned earlier, and I talked a little bit about what that means for you and your family. So the default plan, we'll go into further detail here. It's the assets distributed according to the state law that could go to people you don't want them to go to. So as I mentioned before, if you don't have a plan, I laid out who it goes out to. You may not want it to go specifically to the descendants first. You may want it to go to your spouse first, but you have to be very specific. The kids get the inheritance at age 18 and outright. They could lose it in a divorce if they happen to get divorced, or if they spend it unwisely. And then also the spouse could remarry and cause asset distribution to someone other than your kids as you had originally intended. And also the judge will decide who raises your minor children if you don't have a guardian established. And the judge will decide who is in control of your children's money rather than you deciding. And of course, it goes to what we call probate court, which takes time and money. So what about your minor children? Who will take care of your children if something happens to you? You can name a legal guardian in a last will and testament, and also we could specifically spell out who would take over the responsibility of your children in a trust. If you pass away without a will, a judge will decide who gets custody of your children. So that would be what's called a permanent guardianship proceeding. And keep in mind, as you know, if things going through court do take time and money. So very important to keep that in mind. Now, permanent guardianship proceedings are rigorous, complex, lengthy, and very expensive. So how do you get around that? You designate who you'd like your guardian to be. So often family members battle each other for custody. It could be in-laws, it could be siblings, it could be many different people in the family who may want to battle it out who will get custody if a guardian's not named. So the court will ultimately have to make the final decision. And of course, this, as you can see in the picture, it can be very distressing to children and traumatic. So have a plan to protect your children. It's very important to protect and preserve your children's, I would say, just their life, the lifestyle that they've had. So name guardians in a will or trust is critical. And then also list backups and say what happens if your guardians are divorced or one passes away. It's very important, and I always stress to my clients, always have a backup. It's critical to make sure that your children are cared for the way you want them to be cared for. So guardians outside of the state of Louisiana or outside the United States. So you can basically nominate a guardian anywhere in the United States and also out of the United States. Now, it is important to know that you want to be very specific, the time frame or a temporary guardian if it's somebody outside of the United States until that person is able to come and take control, take over the guardianship of that child. And also you want to make sure you put everything in writing. So critical. And that's where the will and or trust come into play. And a judge will make the final decision. And you want it to be as easy as possible. So once again, making the entire process as easy as possible. So what happens with the money, right? What about the money? Good question, because we always think about, well, we have these material assets, we have our children, we have lessons learned, but what happens with all this money that's out there? Well, that's a great question. Let's dig a little bit deeper. When you think about that, we think about what is an estate, and that's a great question. Many people think you have to have what's I have pictured there on the screen, something huge, gargantuous, I should say. But it actually comes down to the things that I've outlined here: checking account, savings account, car, boat, motorcycle, a brokerage account, a stocks, bonds, life insurance proceeds, a house other than your real estate, other real estate, retirement IRA, 401ks, a coin collection, jewelry, any type of artwork you may have. And this is one that many people forget. Their intellectual property is a key part of that. And then also any business interests you may have, such as an LLC, a corporation, anything like that. So I always like this slide here because I'm all about ice cream, first of all, but it's all about the options, really. You have options, and I want you to know what your options are so you can make the best decision for you and your family to protect and preserve your legacy. So option one, you'll be able to first do a last will and testament, and then option two, a revocable living trust is what you can choose. And let's go through those in detail here. So the last will and testament, it's truly better than nothing. You can name guardians for your children, guardians for your children, and you name beneficiaries for assets owned by you individually, and then you name an executor to wrap up your affairs. So it's basically a very straightforward process with the last will and testament. And keep in mind, of course, it's always best to document something better than nothing. So that's critical to know here. So I just want to go over some of the things where a will can cause some concern, or I would even use the word fail, right? Because you want to take in mind or take into consideration, what's your goal here? To protect and preserve your legacy, which would be part of that would be your children, any of the material assets you have, and also any lessons learned. So here you want to think about it'll be public when filed. It's not applicable to incapacity, so incapacitation or incapacity. So that means if something happens to you, basically you want to make sure you have a filter there, or you want to have some type of net, a safety net there. You cannot cross state lines. Also, the inheritance at 18, I mentioned, it's a one lump sum that goes out to the individual, and no flexibility for basically giving instructions. It's very straightforward, or specifically what's on that document, and you don't have any flexibility of explanation. That would come in later with the trust. So where there's a will, there's a probate process. Very important to know. You will have to go through probate if you have a will. So there's a few downsides with probate. It can be expensive, time consuming, and one thing also, it's public. So just keep in mind, if your child inherits a large sum of money, that'll be public, and then creditors can come out and try to grab at that money that really should be going to your legacy, your child. Probate is expensive. 2 to 7% of the estate assets can be lost in the probate process. That's right. Write that down. 2 to 7%. Now I want you to put an X on that, because we'll find ways to get around that as well, legal ways to get around that. In this case, I want to give you the example of Rebecca. Rebecca's probate estate is $800,000. She had her real estate. She has savings account of $50,000, brokerage account of $200,000, and then life insurance payable to a minor at $2 million, and then 401k payable to the minor at $1,700,000. So a total amount for her estate of $4,750,000. Now, if we just take 1% of that as far as the probate estate tax, then it'll come out to $47,500 lost in probate. Now, I don't know about you, but I'm sure your legacy, your children, could find something to do with that, or your beneficiary could find something to do with that $47,500. So it's really important to keep that in mind, that you want to prevent loss of any kind. Then we come to the example of Sam. So Sam has real estate of $300,000, a savings account of $50,000, brokerage account of $100,000, and life insurance payable to the minor at $50,000, and 401k payable to the minor at $200,000. Now, if you think about that and break that down, it comes out to $1,150,000. If we break that into 1%, then you would lose $11,500. Once again, that could be money that could go back to your legacy, back to your beneficiary, back to your child. And then 3% would be a loss of $34,500. That's quite a big chunk of change that you could actually be saving. So I want to go through a little bit more, and once again, who wants to lose money, right? Whether it be $1, whether it be a chunk of change, everybody wants to save in the process. And I want to show you how you will be able to save in the process. One other thing before I move forward is I want to share the other downsides to probate. It is complex. Families typically need to hire an attorney, hello, here I am, and get a judge's approval on everything. The probate can be a long process, and it often takes several months and even up to a few years to complete everything. So once again, it's complex and it's also a long process. So we want to be able to get past that and make it simple. I truly believe in the KISS theory, the keep it simple student, or in this case, keep it simple will come to you and say, as a strategy, right? A strategy holder. When is a will-based plan appropriate? So an estate less than 125,000 in Louisiana is what you could do what's called a small succession. And that really, if it's less than 125,000, you can definitely go through a simplified process. But also, if there's anticipated litigation, you definitely want to use a will-based plan. And we could talk more about the specifics of your needs as well. So your better option is really a revocable living trust. And we'll go into detail what that means. So a will, it's a will substitute basically. So when you think about a substitute like a teacher or something, a substitute teacher, you do that instead of a will. So you'll do a trust instead of a will. And then you name beneficiaries for your assets in the trust, and the trust is revocable. That means you can change or amend it at any time. And you are the trustee during the life of the revocable living trust. You have total control over that trust. So I want to go through that in more detail. And if you want to if you're taking notes, you can write down control and also trustee. So you're not per se the owner of the item or the asset, because that'll be in the name of the trust, but you do have control over that particular asset. So a revocable living trust avoids probate if properly funded. So basically what that means is everything you own now is outside of your trust. you move your assets into your trust by retitling them to your trust. So, an example, in my case, it would be Gallardo Family Trust. Every asset we owned is then moved into the trust and it's retitled to the Gallardo Family Trust. The benefit of this is that everything in your trust bypasses probate when you pass away. So you're able to save that money that we had talked about earlier. But yet, and most importantly, you still maintain control over the assets in your trust. And that's key, critical to understand. You have control over any of those assets that are in your trust, and yet they are protected. So if you plan for and protect your children or protect any of your beneficiaries with a revocable living trust, you'll gain these benefits. It's far more flexible than a basic will. Your ability to nominate one relative as a guardian, but someone else to incrementally disperse money for the proper care of your children. And then financial care for your children will happen based on your instructions, that deep explanation that I spoke about earlier, in a way that protects those funds from creditors and predators. And money is meant for your children's care. Money that is meant for your children's care will not be tied up until court authentication of a will, which, as we talked about, it could take several months and even several years. So aren't trusts only for rich people? That's a great question. As I mentioned earlier, that's what my sisters and my siblings thought as well, but they're not. A trust can be for anybody out there who wants to protect and preserve their legacy and pass it on to the next generation. So what is a trust? A trust is an agreement that spells out the rules you want followed for the assets owned by the trust when you pass away. So it's very simple, four key elements here. In law school, we would always talk about the elements of a law or the elements of a definition. So once again, a trust is an agreement. It spells out the rules that you want followed for the assets. Once again, those assets you put into the trust that is owned by the trust but controlled by you when you pass away. So those are the four key elements that we want to consider as we go through the rest of this discussion. So to put it another way, a trust does all the things people assume are done by a will. It's done, but it's done more simply, and I'll explain that here as we go through. So I want to give you an example of a trust asset, or a trust example. Dan has one asset of $100,000 in a bank account. He wants to leave it to his son Jimmy when he passes away, but he doesn't want Jimmy to get the money when he turns 18. He's age 25 until he is age 25 and is graduated from college, because as we know, 18-year-olds or most 18-year-olds do not have that maturity level to be able to control their money or a large sum of money at that particular point. So you want that person to be able to mature or get to a point where they're more founded, right? Have a stronger foundation, and you can do that in a trust. So in this case, Dan needs a trust. Remember, putting these kinds of conditions in a will have no legal effect. Basically, you're just putting it, you're writing words, but you can put these into effect with a trust. So it's really important to keep that in mind. These particular pieces, document, wait until he's 25 and so forth, cannot be in a will, but it can be in a trust. So there are three roles in every trust, and it's interesting because Louisiana is a little unique. Most of the time, people call it a grantor, the person who contributes into the trust or funds the trust, as we talked about, puts the assets or the monetary value into the trust. And Louisiana, we call it a settler. So in law school, what I did to be able to go through the process of understanding what a trust is, I would always tell people to draw a triangle. So if on a piece of paper you can write a triangle or draw it out. On the top prong of that triangle, you can write the word grantor / settler. And that's the person who's contributing to the trust. So in this case, it may be you, it could be your husband, it could be whomever's creating that trust. So in my case, Gallardo Family Trust, the grantors or settlers are my husband and I. Then on the prong to the left of on that triangle, the bottom left, you can put the word trustee. And this is the person who manages the trust. So in my case, it would be my husband and I who manage the trust. So we're in control of the trust. All the assets are owned by the family Gallardo Family Trust, yet we're in control of it as trustees. Then on that same triangle on the bottom right-hand side, you can put the word beneficiary. So the beneficiary is a person who is entitled to the assets. And in this case, in my example, the beneficiary for our family, our trust would be our son, Elijah. And so he would be the one named as beneficiary. And then while we're living, my husband and I, we would also be included as beneficiaries. So we could have multiple roles. In this case, would be the grantor, trustee, and beneficiary, along with my my husband and my son. So I hope that's it helps clarify a few things and gives you a visual as well regarding what the terminology is for a trust. So the gift of total control is critical and mainly what most families want, right? So I'll give you the example of Henry and Wanda. They occupy all three positions, just as the example I give you with my husband and I, Dennis. We're the grantors and the beneficiaries and the trustees as well, or in this case, grantors slash settlers. So once again, those three roles in every trust are important to understand. And Henry and Wanda, they're in control. My husband and I are in control of those assets, and the trust can be amended or revoked at any time. If we want to make a change while we're living here, we can make that change. And that's what the benefit of a revocable living trust. You can make those changes. It's revocable. So I love this analogy here. So think about a backpack, think about any child's backpack, or even you have a work backpack. A revocable living trust is like a kid's backpack or your backpack, right? And we'll dig deeper into that because I love this analogy. So basically with that, just thinking about it, it avoids probate for all things that are inside the backpack. So anytime you're thinking about, well, what's in my trust, what's not, it's whatever you put into your backpack and you've changed or retitled to your family trust name. So in my case, Gallardo Family Trust, everything we have retitled and renamed would go into that backpack, and that's part of the trust and protected and preserved. So what's interesting, a trust solves all the problems that come with a will. You won't lose the 2 or the 7% of your estate in probate court. The assets go to your loved ones in weeks, not years. That's really important. It's a more expedient process. And then totally private during your life, and at death. It's private. Rather than going to clerk of court or be it in court as a public matter, it's something that's private. Nobody will know about that. It's a protection for your legacy, for your children, for your beneficiaries. Excuse me. Skip the slide here. Sorry about that. So if you think about this, living trust and guardians. So with a living trust, your family will get access to your assets and your money much sooner than with a will. Your designated guardians will take custody of the minor child immediately. And as I mentioned earlier, if they're out of the state or country, you can designate temporary guardians until that individual gets into the area to be able to oversee the care of your child. And you may want the nominated guardian to have access to the account or to the money as soon as possible as a resource for your child. So these are some things that parents worry about that could happen after they're gone. And for example, their adult children get divorced and the family assets go to strangers that they don't even know because this has happened after they've passed away. And then their adult children lose their inheritance to creditors or lawsuits. And I'll give you some examples about that here. And something that's pretty interesting is that is each child ready for a huge lump sum distribution of cash at age 18? That's a great question. Most are not, as I mentioned previously. So according to Financial Planning Magazine, it says, it quoted, clients' biggest concern for their wealth after they're gone is that someone will take financial advantage of their children or grandchildren. And that is so true. And that's why this discussion today, protect and preserve your legacy, is so, so important because you want to make sure that protection is consistently there for your family, for your legacy. So I want to introduce to you, and you can write down, like you think about the ancestry DNA or all these family trees. So if you're creating a family tree on a piece of paper, I'd like you to put on your paper, the parents would be David and Sarah. So those are the parents on top in your family tree or your chart. And then they have 2 children, and the 2 children are Denise and Sam. You can see them there on the screen. It takes me back to law school because we always had to, in our succession class, we had to write down the specifics of the family tree and know what, where. So you have your tree laid out. You have the parents, David and Sarah, and then you have Denise and Sam as the children. So Denise's husband, Richard, so next to Denise, you can put Richard. He's inherited funds are often commingled with jointly held assets. So in Louisiana, we're a community state, as I mentioned, but inherited funds are separate property. If they're inherited before, so yes, they're separate property. But if they're commingled, then a case can be made that they become community property. So they'll be jointly held assets. And if that's the case, if they get divorced, Richard gets half of that inheritance. So everything that everything that would have been given to Denise would then go, half of it go to Richard. So that definitely is not a protection of the assets that you would have intended to go to your daughter. So we want to keep that in mind as we go through this. So another interesting point here about Sam, he's accident prone. So we know people like that, I'm sure. Sam accidentally left the water running in his bathtub and he went out for the night. So what happens? Well, of course, the downstairs floods. The neighbor sues Sam and he loses his entire inheritance, settling that particular claim. Now, I do want to tell you, it could have been protected if it would have been placed where? That's right, in that trust, in that backpack. That's how you can protect from divorce or from other issues with commingling, and also from issues with any type of settlements or suits. So what I like to compare a trust to is like, if you think of a toothpaste tube, right? A distinct trust for your children can operate like a tube of toothpaste. So we can create what's called a children's trust within that trust, your family trust, to be able to protect your children. And I'll explain a little bit more about that. So it safeguards your inheritance in your plan by creating that trust for your child that will hold on to their inheritance. It's like a tube of toothpaste, as I mentioned. You can squeeze money out when your kids need it, but what remains inside the tube is protected from divorce, lawsuits, creditors, and bankruptcy. And you can designate the trustee, and this can even be an adult child. So you see the awesomeness of that? Your adult child can be the trustee in control of that children's trust, which is their trust, and they will be the beneficiary, and they can pull things out or money out as they need it and keep it protected within that trust. So it's just a great way to protect and preserve your legacy and allow your children, your legacy, to protect and preserve their legacy. So I love this this picture here, because your plan can put protections in place, and just a little bit at a time, right out of that toothpaste, just a little bit at a time, or a little bit out of your trust, protecting the rest of it that's in your trust. So how does it work? A revocable living trust avoids probate. You can also, or we can, create a trust for your children. It protects your children's inheritance from lawsuits, bankruptcy, and divorce. And a lot of times at death, there are what's called estate taxes, right, that are due. So right now, as of 2022, estates greater than the amounts of $12,060,000 for an individual and $24,120,000 for a couple do not acquire federal estate tax. So if you're outside of that 12 million mark or 24 million mark, you don't have to worry about specific estate taxes. Or if you're within that realm, I apologize. If you're outside, you do, and we can talk specifically about that. Rules are different if you and or your spouse are non-citizens, and I can also discuss that separately if we need to discuss that. So how big is your gross estate? And something to keep in mind is your gross estate includes life insurance, proceeds paid to you at your death. Laws change. You could have a taxable estate in the future, even if you don't have one today. And you can avoid or minimize taxes due with the help of an estate planning attorney. So what I'd like to tell people at this point is that laws change. We know that. Something I learned in law school is that law is a fluid living thing, right? It can change at any point. So what I like to do with my clients is actually through a membership program, we're able to go through their particular estate plan, whether it be a will or a trust, making sure it's the best benefit to the best benefit of them individually and their family at all times. And just keep up with any changes that may happen there. Plus, there's other great benefits that I can discuss in detail as well. So the next steps, what are the next steps? Well, obviously, we know we need to do something. So you've taken in a lot of information today, and I say a lot. So if you're taking notes, you have the notes, and I'll also send you this recorded webinar as well to have and go back to. So you need an action plan. As with anything in life, we need an action plan when it comes to your estate planning. So what do you need to do? How can you make it happen? When should you get started? And what's the investment to get it done right? All great questions, I can assure you, and many have had the same questions as you. So it's important to make sure that you find the right attorney. And I just want to talk about 5 key pieces here that it's important to consider. Is the attorney's primary focus on estate planning? Does the attorney work with your other advisors, such as insurance, tax, and financial advisors? Does the attorney charge a flat fee? And state clearly what you are getting. Does the attorney have a process to keep your plan up to date? And ask yourself, can I see myself working closely with this attorney? 5 great questions. And I can assure you that in the first one, definitely my primary focus is on estate planning. Also, I will and can work with insurance, tax, and financial advisors, and I do charge a flat fee. And I state specifically and clearly what you're getting. It'll be crystal clear. And I do have a process to keep you up to date. And part of that is that membership process that I mentioned. And I hope you can see yourself working closely with me in this case. So what does that mean for you? There's a 6-step plan to protect and preserve your legacy. First, you attend a class or webinar such as you're doing today. You can check that off. Then we set up a legacy planning session that would be a 60-minute discussion with me. We'll go into further detail about your specific estate. And then we'll set up a call after that, a strategic design session, where during the process between legacy planning session and strategic design, you'll have some homework. Don't worry, it's not going to be hard homework, and I'll give you specific guidance regarding that. We'll talk about the specifics that you turn in at the strategic design session, where we design your specific trust and or will. We document review. We have a document review session, and then we do a signing ceremony, and then you get your complimentary annual plan review. And that's included. And then plus step number 6, throughout this process, you can consider the membership option that I mentioned earlier. So who is this peace of mind or this legacy planning session for? It's for people who have watched this online class or recorded webinar so that you can make an educated, informed decision. And people who do not have an estate plan, or people who believe that their plan is outdated, and people who are ready to get started with the process. So if you fall into any of those categories, including residents of Louisiana, of course, then this is for you. I can guarantee you this is for you. So let's talk about cost. What's the cost of failing to plan? And I can tell you, I personally, my team and I, we will only recommend planning if the amount that will be saved by planning is more than our fee. So keep that in mind as we talk about this. And there'll be specific numbers that we'll discuss regarding that when we have our legacy planning session. So some of our most popular packages include the revocable living trust and a pour-over will, a children's trust, a power of attorney, which, as I mentioned, is bundled, advanced healthcare directive, HIPAA waiver, a living will. So that's one section. And then also we have the living will, nomination of guardians, final disposition instructions, a portfolio binder, and electronic copies of your documents. So this is what's included in many of our popular packages as I go through this. So I do want to tell you that because you have listened in today and you're listening to the recording, you will have 72 hours to set up a legacy planning session with me. And when you do, you will get the legacy planning session at no charge, which normally there is a $525 charge. I will give it to you or grant it to you at no charge. So the value, it's a great value based on what we will be discussing to protect and preserve your legacy. So your next step is booking your legacy planning session. And I've included my information here. If you go to www.freestrategycallwithcynthia.com, we will be able to set up your legacy planning session, and then we can take that next step to be able to talk about your estate plan strategically. So with that being said, I just want to see if there's any questions out there from anybody. I know we covered quite a bit of information here. A lot of information, in fact, regarding the difference between a trust and a will. And I want to make sure you have what you need as you go back and make your decision for you and your family. If you have any questions, please feel free to type in the message in the chat. You can type in the chat if you have any questions, anything you want to get clarified in this particular discussion. And if not, I can definitely grant you back some of your time today. I know I had mentioned it would be about 45 minutes, which we're pretty close to it. But I always want to make sure that I leave plenty of time for questions and answers. So once again, knowledge is not enough. Knowledge is power. It's not enough though to keep your legacy protected and preserved. So I'd love to be able to help you do that. So if there are no questions, I'm checking the chat. If there's no questions or anything, I will go ahead and close out this session here, and we will be closing it out. Once again, thank you for joining today. My name is Cynthia Gallardo, your leading legacy lady, and I would love to be able to help you protect and preserve your legacy. Thank you once again for joining. You can sign up at www.freestrategycallwithcynthia.com. Have a great day and continue protecting and preserving your legacy. Thank you so much.